Yeah, thank you, Mr. Chairman. It was a pleasure to work with Chairman Green and his staff. It was an absolute pleasure. I learned a lot, and hopefully I can explain in a relatively short period of time what we learned during this impeachment investigation and prosecution. Take a step back, try to give you the essentials of the narrative as I understand it. Let's go back to the Constitution. They're drafting the Constitution. They wanted to create an impeachment clause to remove high executive officials because they knew the criminal law was not adequate to remove bad actors. So at the Constitutional Convention, there was a debate. What standard should govern high executive officials being able to remain in office? The phrase maladministration was thrown out there. But Madison objected to that. He said, no, we don't want a standard where it's just where you can remove someone just for being a clumsy administrator. We want to go to what was proposed next, which was the phrase high crimes and misdemeanors. Now, that may seem vague to some people today, but at the time it was imported into the Constitution because it had a clear history of application in England for over 100 years. That was the phrase, high crimes and misdemeanors. Now, that was ultimately the standard put into the Constitution. Now, what does that mean? A high crime, and I think, although there's some debate on this, whether high modifies misdemeanor as well, I think it does. A high misdemeanor, what is that? It was understood to mean not a petty crime as we understand it today, but a misconduct in your demeanor in high office. A high misdemeanor was misdemeaning yourself in your conducting of a high office. And that's really the central part of the impeachment claim against Mayorkas. Fast forward, that becomes part of the Constitution. The first Congress, James Madison, is elected to the first Congress. There is debate on whether to create a Department of Foreign Affairs, which ultimately became the State Department. There is objection on the House floor. Let's not create this department, people say, because there could be bad actors. There could be really bad people that have a lot of power in this department. And James Madison says, no, wait a minute, relax. We can go ahead and create this department because we have the power of impeachment, and we can remove, through impeachment, unworthy men, his phrase, who may occupy this office. You know, not referring to the president, but to some unworthy men that might be appointed to these positions. So what we have here, Joseph Story was one of the first great commentators on the Constitution. He wrote a treatise that described some of the major precedents under high crimes and misdemeanors in England, which included multiple examples, for example, of admirals in England who failed to control their borders at sea, opened them up to invasion, opened them up to harm. These were all considered impeachable offenses for their neglect of duty. So fast forward today to the case of Secretary Mayorkas. Now, there are two things that make this impeachment unique, I think, in constitutional history. The first is the subject of the violations involve federal statutes that explicitly deny prosecutorial discretion to high executive officials. They say, for example, 8 U.S.C. 1226C, if a border agent comes across an illegal alien and through their database check or otherwise they're determined that to have been convicted of an aggravated felony, which is defined in the statute as things like murder, sex trafficking, drugs, you shall detain that person. Doesn't mean you have to go around and find these people in the weeds, but insofar as you encounter them, you must detain them. So the Secretary, in the face of that statute, on September 30th, 2021, issues a memo. And it's got his signature on it, and it's all publicly available. So much of this impeachment is also unique because parts of it were like almost gift wrapped with a bow and sent to Congress, because this is public information. These are policies they were proud of. This was not a matter of having to subpoena people and dig up information about what you hid or didn't hide from Congress. In Watergate, it was, the abuse of power in that way. And, the first Trump impeachment, it was contempt of Congress. This was all in the open and fully litigated. So this September 30th, 2021 memo that Mayorkas sends out says, the decision how to exercise prosecutorial discretion can be complicated and requires investigative work. Our personnel should not rely on the fact of conviction or the result of a database search alone. That is an absolute 180-degree violation of the requirements of the federal statute. This was litigated. Texas, United States v. Texas. Texas says this is obviously an unconstitutional order to his entire staff to violate federal law. And the lower court agrees. And it goes up to the Fifth Circuit Court of Appeal. And the Fifth Circuit Court of Appeals agrees that this is a clear violation of the law. And then it goes up to the Supreme Court, and things get interesting. The Supreme Court takes the case, and the decision says, the majority decision, which was this kind of mixed group of Kavanaugh, Roberts, and the 3 liberal justices. And they say, well, wait a minute here, this sounds like an issue to us of whether there's too much or too little enforcement on the part of the administration. We don't think, this was the 5-person majority, that this is an issue that we should decide ourselves as the judicial branch. We think this is a decision for Congress. Now, they leave open how Congress should handle this. They list a variety of tools that Congress has. But the important point is that during the oral argument in that case, the oral argument in a case is when the justices and the litigants much more openly discuss the practical ramifications of what their decision might be. Justices don't want to be blindsided by some consequence of their decision that they didn't fully explore. So during the oral argument, you'll see a lot more blunt questions and blunt answers. And what happens at the oral argument is the Solicitor General of the United States, who is charged with articulating the Biden administration's official policy position, she's arguing to the court that they should not, there should be no jurisdiction in this case. They shouldn't even answer the question. And this is what Justice Kavanaugh says to the Solicitor General of the United States during the oral argument. I think your position is, instead of judicial review, Congress has to resort to shutting down the government or impeachment or dramatic steps if some administration comes in and says we're not going to enforce laws, or at least not going to enforce the laws to the degree that Congress by law has said the laws should be enforced. That's 8 U.S.C. 1226C. And that's forcing. I mean, I understand your position, but it's forcing Congress to take dramatic steps, I think. And the Solicitor General responds, well, I think that if those dramatic steps would be warranted, it would be in the face of a dramatic abdication of statutory responsibility by the executive, which is exactly what an unconstitutional order to your entire staff to violate a clear federal statute is. So that was the quid pro quo. That was the quid pro quo. Court, if you deny jurisdiction here and you don't answer this question, we will take our chances with impeachment. Now notice Kavanaugh just flags impeachment and shutting down the government. Well, of course, shutting down the government is no solution here, because if you deny funds to the administration, they won't have any funds to implement the law. And if you give them more funds, you'll just be wasting money because they've demonstrated that they're not going to enforce the law. So the only practical remedy here is impeachment. And in fact, the concurring justices all agreed. They said, of course, the states have suffered vast harm. Their health care costs have gone up. Their crime rates have gone up. Of course, there is harm. So that left the Senate as the sole source of relief after the House passed the impeachment articles over to the Senate. You would think that the senators would understand that they have a unique responsibility to defend the interests of the states. They are unique in our federal system for being elected statewide, so they do have a special obligation to the states. They are no longer elected by state legislatures, but they're still elected statewide. The fact that so many senators voted for Schumer's proposition that somehow this was an unconstitutional move by the House is really outrageous in the sense of they're violating their duty to their own state interests. So if you really look at what Schumer said, he said, well, this was unconstitutional on the part of the House. Well, he couldn't have meant that it was unconstitutional for the House to consider articles of impeachment. That's in the Constitution. The Constitution requires the Senate to evaluate through a trial in the admission of evidence whether or not this was a constitutional or unconstitutional impeachable offense. Did it rise to that level or not? So when Senator Schumer says we're going to vote to dismiss this right away because he thinks it's unconstitutional, That is like the Queen of Hearts in Alice in Wonderland, who said, verdict first, trial later. But it's much worse. He ended up saying, verdict first, no trial ever. Much worse than the Queen of Hearts. And the entire point of the process was for the senators to hear the evidence as to whether or not this was an impeachable offense. And he denied even that most minimal step, effectively negating the impeachment clause, writing it out of the Constitution, leaving it now just to voters to decide whether or not the senators who supported that principle or lack of principle might be punished at the ballot box.